The controversy at hand began when the Karnataka government issued a government order mandating 1 day of paid menstrual leave every month for women employees. The policy applied broadly and was projected as a progressive labor welfare measure recognizing menstrual health at workplace. The decision quickly drew national and international attention, which highlighted Karnataka as a rare example of a government formally acknowledging menstruation in employment policies, hailed as a positive step for the welfare state, along with a sigh of relief. However, soon after the notification, the policy was challenged before the Karnataka High Court. The petition at hand, filed by Bangalore Hotels Association and management of AFL Connectivity Systems Limited, argued that the state had exceeded its powers by introducing paid leave through an executive order without specific legislative backing under existing labor laws. They contended that such a notification was issued in violation of principles of natural justice, as all the stakeholders before introducing such a move were not consulted. In this case, the stakeholders being the management bodies who filed the petition, of course. Taking note of these objections, however, the Karnataka High Court stayed the operation of the menstrual leave notification, putting the policy on hold. The court's order signaled that the issue was not about the idea of menstrual leave itself, but about whether the government had the legal authority to impose it in this manner, without a well-laid statutory enactment. Subsequently, the High Court began hearing the plea in detail, with the state defending the policy as a welfare-oriented and inclusive step aimed at supporting women workers. The court indicated that the matter involved questions of public importance and required careful examination. As things stand, the dispute remains unresolved, with Karnataka's ambitious menstrual leave policy caught between progressive intent and constitutional scrutiny. While this courtroom battle goes on, it is worth noting that a move like this isn't as rare or new to India as it may sound. In fact, you can trace its roots back to a century in India. As early as 1912, a government school in Kerala quietly allowed female students to take menstrual leave during annual examinations and reappear later. This wasn't framed as activism or reform. It was simply a practical acknowledgement of menstrual health introduced at a time when even discussing menstruation publicly was taboo. Fast forward to independent India, and another quiet but significant step came from Bihar. In 1992, the Bihar state government issued a notification granting 2 consecutive days of special leave every month to female employees working under state-controlled organizations. What's striking is that this was not a pilot or a temporary measure. Informal discussions with officials have reportedly confirmed that the policy continues to be in practice even today. The Bihar Vikas Mission, a state body implementing government schemes, explicitly recognizes this benefit in its human resource manual. These examples show that menstrual leave in India has largely evolved outside courtrooms and headlines. But these glimpses of progress are not enough. As we move closer to the recent years, the story also needs to focus on the parliament and maybe a pattern of neglect. In 2017, a private member's bill called the Menstruation Benefit Bill was introduced in the Parliament of India by Neenong Ering, who was then a Lok Sabha MP from Arunachal Pradesh. The bill proposed 4 days of paid menstrual leave per month, additional workplace benefits, and even a grievance redressal mechanism. But despite its scope, the bill was never taken up for discussion. Years later, in 2022, Ering, who was an MLA, reintroduced it into the Arunachal Pradesh Legislative Assembly, only for it to be withdrawn shortly thereafter, leaving the legal position unchanged. In early 2023, the issue resurfaced in the Lok Sabha through a set of 6 questions addressed to the Ministry of Health and Family Welfare. The list of questions asked whether the government was considering mandatory paid menstrual leave across workplaces. One question specifically referenced a public interest litigation filed in the Supreme Court, highlighting that menstrual pain can severely affect productivity and may be comparable in intensity to heart attack pain, asking simply whether the government was even aware of this ongoing matter. Leaning on Miles Davis for a reference, the response was striking not for what it said but for what it avoided. The ministry's reply opened by stating that menstruation is a normal physiological phenomenon and only a small proportion of women experience severe dysmenorrhea, most of which it claimed is manageable with medication. After that, the response did not engage with the questions at all. There was no acknowledgement of the public interest litigation mentioned in the questions, no discussion on workplace impact, and no policy reasoning, just a pivot to unrelated information. What followed were paragraphs detailing government schemes on menstrual hygiene awareness campaigns, distribution of sanitary napkins to adults and girls, and implementation through the National Health Mission. Important initiatives, no doubt, but completely unrelated from the question of paid menstrual leave for working women. In effect, 3 paragraphs were used to sidestep the issue raised entirely in a typical exercise of ignorance. This is where the contrast becomes sharp. While lawmakers and the executive have largely chosen to ignore or deflect the demand for menstrual leave, the Supreme Court of India and various high courts have at least engaged with it through PILs, through hearings, and through policy scrutiny. The result is a familiar Indian pattern. legislative silence, executive dismissal, and the judiciary left to push the conversation forward one case at a time. This judicial engagement becomes even clearer when we look at how existing constitutional principles already support something like a menstrual leave. In Francis Corley versus Union Territory of Delhi, the court expanded Article 21, holding that the right to life is not just about survival but about living with human dignity. Seen through that lens, compelling women to work during menstruation without any option of leave directly affects their physical comfort and mental well-being, and arguably underlines that constitutional guarantee. Then there's Vishakha versus State of Rajasthan, a case best known for workplace safety but deeply relevant here. The judgment recognized that workplace cannot force women into situations that are uncomfortable, unsafe, or humiliating. Denying menstrual leave, critics argue, can push women into precisely such situations, indirectly reinforcing discrimination and violating the equality mandate under Article 15. And then there's Sampurna Behura versus Union of India. The court made it clear that the state has an affirmative duty to provide health-related support to women. Denying rest and recovery during menstruation, therefore, can be seen as falling short of that obligation. Put together, these cases show something important. Even without specific menstrual leave law, jurisprudence offers a decent foundation which had to exist because effective legal frameworks don't offer anything comprehensive. The real question now isn't whether the courts can justify menstrual leave, but whether lawmakers are willing to act on the principles that judiciary has articulated for decades now. Several employers in India have taken the lead by offering period, or FOP, first day off period leave, to support women's health. Culture Machine and GoZoop were among the early adopters, allowing women employees to take leave on the first day of their period without needing a medical certificate, an initiative that got widespread media attention when it was reported. The kings of the gig economy like Zomato also introduced period leaves as part of its broader workplace benefits, signaling recognition of menstrual health in a fast-paced startup environment. Swiggy extended its support beyond just office staff. In 2021, the company announced benefits for its women delivery partners, including menstrual leave, as part of its efforts to increase female participation in the delivery fleet. And Byju's updated its leave policy to include period leaves alongside other family-friendly benefits like childcare leave, positioning it as a part of a broader commitment to employee well-being. These corporate policies show that some private sector employers, regardless of how exploitative generally are towards the lowest line of workers, are responding to calls for menstrual support, even in the absence of a nationwide legal mandate. And this is where the Bihar story turns uncomfortable. On paper, Bihar was ahead of its time. Back in 1992, the state introduced 2 days of special menstrual leave for women employees. For its era, that was nothing short of progressive. But fast forward to today, and the ground reality tells a far more troubling story. According to data from the National Family Health Survey, the use of hygienic menstrual protection among women aged 15 to 24 has improved across India. Bihar, interestingly, recorded one of the largest jumps, about 28 percentage points. Yet despite this improvement, Bihar still ranks at the bottom, with only 59% of young women using hygienic methods about menstruation. States like Assam and Gujarat fare slightly better at around 66%, but Bihar remains the lowest. Ground reports from Bihar explain why numbers alone don't tell you the full story. Reporting by 101 reporters shows that for many girls, menstruation still disrupts education entirely. Lack of affordable sanitary products, inadequate toilets, and deep social stigma mean that girls routinely miss school during their periods. Not by choice, but because the system offers them no support. So the irony is really hard to miss. Bihar introduced menstrual leave decades before the national conversation even began, but leave policies help only those already inside formal workplaces. For millions of girls and young women outside that bubble, menstrual leave hygiene remains a daily struggle. Globally, the first real legal push for menstrual leave came from Japan, and as early as 1947. Under Article 68 of Japan's labor standards law, employers are required to grant leave if a woman finds it especially difficult to work during her menstrual period. On paper, it was groundbreaking, but the gap between law and lived reality caught on. Today, some studies show that only about 0.9% of Japanese women actually take menstrual leave. Why? Because asking for it often means explaining intimate details, how painful your period is, how long it lasts, to a boss who is usually male. For many women, that conversation is simply too much of a violation of privacy. The problem runs deeper than this. Japanese work culture is notorious for its commitment to working all the time. Anything that signals reduced commitment, whether it's caring for children, elderly parents, or your own health, is seen as a weakness. Work is viewed as service to society itself, and stepping away from it, even briefly, risks being labeled unproductive or maladjusted. There's also intense community pressure not to take time off at all. long vacations included. As a result, fewer companies now offer menstrual leave, and nearly 3/4 provide only unpaid leave. Even when women do take it, the cost is high: lost pay, reduced holiday entitlement, or quiet professional penalties, especially troubling in a system where women already earn less than men in similar roles. Japan's experience delivers a sobering lesson. Changing the law is not going to be enough. Without cultural change, legal rights can exist in a vacuum, unused. Indonesia offers one of the most revealing stories on menstrual leave. The country introduced a menstrual leave policy as early as 1948, soon after independence, making it one of the earliest adopters globally. Influenced by gender roles shaped during the Dutch and Japanese colonial rule, Indonesian labor law recognized women primarily through a protective lens. Under the original law, women workers were allowed to take 2 days of paid menstrual leave each month. Employers had no discretion. Women were expected to rest at home, and if they worked instead, companies were required to pay them extra compensation. But the policy began to unravel after the fall of Suharto in 1998. During labor law reforms, the government revised this obligation. Under Law No. 21 of 2003, menstrual leave still exists, but only if employers and employees mutually agree. One reason cited was that many women, especially factory workers, chose not to take leave and instead opted for the additional allowance. This increased costs for the employers, and during the politically volatile reform period, industry pressure played a significant role in diluting the mandate. Today, the law offers no clear guidelines on how menstrual leave should actually be implemented. Beyond the law, social realities can make things harder. Across Indonesia, menstrual stigma, taboos, and myths heavily shape women's lives. Menstruating women are often barred from religious activities, cooking and eating certain foods, or even washing their hair. In some remote communities such as Hualu village in Moluccas, women are isolated in menstrual huts for nearly a week based on beliefs that menstrual blood is dangerous or contagious. Even in cities like Jakarta, misconceptions persist. Severe menstrual pain is sometimes dismissed as weakness, with marriage or sex framed as a cure. Talking openly about menstruation remains taboo. Women use coded phrases like datang bulan, translating to coming of the moon. They hide sanitary products and fear being judged as immoral for speaking openly. What these examples really underline is that there is no single way of drafting these policy measures, but intent definitely matters. In Taiwan, the policy is explicit. Menstruation recognized as a legitimate workplace health concern, and women are given 3 designated days off to deal with it. By naming the issue, the law removes the shame and ambiguity, treating menstrual health as part of routine labor protection rather than an exception. Zambia, on the other hand, takes a different framing. Its Mother's Day provision avoids medicalization altogether. No explanations, no certificates, no intrusive questions. This can be seen as an example of how worshipping women's fertility can be used as ammunition for progressive policies. Although one could argue about its overarching perception of child rearing being the most important life goal for women and call it benevolent patriarchy. But that's a discussion for another day, given how difficult it is to push the needle even slightly in the right direction. As reported in an analysis by Resolve Global Health, this kind of flexible leave can actually be more empowering because it sidesteps stigma and gives women autonomy over how and when they use it. The broader takeaway is this: menstrual leave works best when it's framed as workplace equity and not charity. Whether clearly labeled like Taiwan's or uniquely embedded like Zambia's, it shouldn't be a shock to anyone to know that caring for your employees' needs and health actually boosts productivity and it actually increases their incentive to work. Such policies can improve retention, productivity, and dignity, but only if workplaces also tackle silence, stigma, and structural inequality. Without that cultural shift, even the most progressive laws risk becoming benefits that exist on paper but not in practice. India is not a place where there would be a 100% implementation and acceptance rate if something like a uniform and comprehensive menstrual leave policy comes to life. But that does not mean we don't do anything. Sometimes we forget that improvement is a process, not an event. And as for why this discussion should have an important place in national discourse, it's because it is not a single issue struggle or an exclusive struggle for people who menstruate. This is a workers' rights issue, an issue for safety and health, and most importantly, an issue of dignity for half of our country's population. We'll keep tracking the dispute in Karnataka and how it affects the rest of the discussion surrounding women's health and workers' rights. And if you want to gain access to these hearings and more, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law.